Hi everyone. My today's live will be dedicated to partner visas, which I truly adore because every partner visa carries a love story. So, before we begin on a partner visa journey, let me introduce myself and introduce some ground rules. First of all, my name is Yulia Moiseeva and I'm a registered migration agent. I own my own practice here on the Gold Coast, Queensland, and we provide assistance with all of visas except protection and asylum visas with myself and my team. So for any needs of partner visa, we can cater your case. We also cater for visitor visas for those who are in early stage of relationship and wish to come to Australia to visit the partner and get to know the family. So I've been practicing in migration field since 2010, and we have a various knowledge over partner visas, prospective marriage visas, visitor visas. So today I will be discussing all these options, and I will be happy to take any of the questions from the floor. While I'm going to be discussing those options, feel free to put your questions in the chat. And once I'm finished, I will be attending those questions. So let's begin. Let's rewind the whole options for partners from the very beginning. If yourself is a prospective partner and you are searching for the partner in Australia, or you already met somebody online, as an example, the first option is to meet in person. Those options can be meet in person in your home country, as an example, to invite your prospective partner there and see how you go. Another option is to arrange any short holidays together in the third country. And usually people are meeting where the visa regime is the least problematic. So any country without visa requirements or visa at the entrance. And other option is to consider visitor visa to come and visit your partner in Australia. In case if you would like to do that and come and visit your partner in Australia, you should consider visitor visa subclass 600 for majority of cases, unless you have a passport from the country where you may get e-visitor visa. But 600 visitor visa must be in tourist stream. Do not use family sponsored stream. The reason for that is, for family sponsored stream, especially when you are in the early stage of the relationship, your partner may not be eligible to be a sponsor. And if you are at the sufficient stage of the relationship, then this type of visa will bring compulsory condition that will not allow you to lodge any other application while in Australia. So tourist stream of visitor visa subclass 600, that's the usual scenario where partners can come to Australia, meet with family, meet with partners, spend some time together, and actually decide whether this relationship will go ahead and will be developed. If for some reason visitor visa is not granted, but you manage to make your first face-to-face meeting anywhere in the world, and you will have sufficient evidence of that. Usually it's your tickets, your hotel stay, and your photo together. That's absolute minimum. Then you will be able to consider prospective marriage visa 300, where you and your partner will be disclosing to department and preparing all the evidence showing that both of you will be partners in the future, because 300 visa will require the applicant and sponsor to book the marriage ceremony way ahead, minding the consideration time for the visa. So in this case, you will be providing, I would say, less evidence of you being a couple right now, because you're going to be in the early stage of your relationship. At the same time, this visa will allow your partner to come to Australia, and you have sufficient time to plan your marriage, execute the marriage, and then based on that marriage, to apply for partner visa. So that's a stream and pathway for people who do not want to come on the visitor visa or who couldn't come on the visitor visa. Then 300 visa, marriage, and partner visa in Australia will be the appropriate pathway. If the applicant manages to get 600 visa and there is no restriction on that 600 visa or any other visitor visas, and the applicant and sponsor pretty much are ready to commit to the relationship, and they can either satisfy any of these three streams. They've been in de facto relationship living together for 12 months. For example, that may happen overseas already. And then the applicant will come to Australia on the visitor visa and then proceed with partner visa. If applicant and sponsor hasn't been together, living together for 12 months, but they will be residing in the following states and territories: ACT, New South Wales, Victoria, Queensland, South Australia, and Tasmania. In those states, there is a opportunity to register de facto relationship and have at least evidence of your relationship living together, satisfying all four pillars for at least 3 months while you are on the visitor visa. In this case, people may come on the visitor visa, live together, register the relationship, and then proceed with partner visa. If you cannot execute the first two options, so you haven't been living together for 12 months, and where you're going, for example, to Perth, WA, you cannot register de facto relationship, then you can explore the opportunity to come on the visitor visa and apply for marriage, and then based on marriage, apply for partner visa. Usually, department does not quite like the idea of rushed marriage, I would say. So be mindful on that. When you're going to be looking at lodging partner visa application, it's a very important point that at the time of lodgement, the couple will have to provide sufficient information on the four pillars of relationship, meaning your joint financials, can be joint bank account or two separate bank account, but you minding your financial affairs together, joint bills, superannuation beneficiary, any other legal commitments, joint rent, your social life, how many friends you know to each other, whether your families accept you as a couple. It will be declarations from both of you, applicant and sponsor, declaration from friends and family, colleagues. I would suggest to start with friends and family and then move to colleagues, work colleagues. Then social life can be covered by your photos, any memberships, invitations, travel together. Household pillar, where you have to provide how you run your household together. Again, it's going to be a mixture of joint bills, your joint rent, evidence that you receiving correspondence to the same address. For example, you have driver's license to the same address, you are included both in the same health insurance, car insurance, etc., and your commitment to each other, where again you're going to be preparing your statements, and it's not going to be just statement based on pure facts. I suggest that in every statement you need to include a bit of emotional component of your relationship, showing how you actually develop your relationship from the day you met each other and then how you decide to be a couple, etc. So these statements will be prepared individually for applicant and the sponsor. Of course, they're going to be very look-alike, but you cannot copy paste. So it needs to be individually written. In terms of commitment, you also can use long-term commitment depending on your needs and discussion as a couple, like will or including your partners as a beneficiary in your superannuation account. Every single couple and their life are pretty much different. So you can go, of course, on the list of documents and see which scenario may fit you best. However, the important thing is that you have to cover all aspects of your relationship at time of lodgement. If any of these pillars will be missed and evidence is not provided, then department can request the evidence or can reject the application. And currently, the application fee is quite high, starting from $9,095 per one adult on a partner visa application or prospective marriage. So it's a lot at stake, and your application must be prepared to the best ability. When we're talking about partner visa, the other potential option will be offshore partner visa. I would say this option is not widely used. The reason for that is the processing time of partner visas may take up to 2 years. And in the recent 2024-2025 year, we saw the significant increase in processing time, where the previous years show around 3 to 6 months after lodgement. The 2024-2025 showed around 12 months plus lodgement on variety of applications, variety of nationalities. So I would say the processing time increased, unfortunately, but the beauty of pathway where the applicant is coming in Australia on 600 visa and then progress to partner visa is the best in terms of you staying together as a couple and you simply waiting the decision while in Australia. So for those who will be exploring this pathway, the also bright side of it is that once the application is lodged, the applicant will have access to Medicare. And once a bridging visa is issued and become active after visitor visa expires, then there will be full work rights on the bridging visa. So it's pretty much you setting up your life, applying for the partner visa in Australia, and then live together and wait for the decision. So usually the normal scenario of processing 600 visa, then partner visa 820. Since the time of lodgement, you need to wait 2 years to then be eligible to apply for permanent residency, but temporary visa should be processed earlier than 2 years. So from the time of lodgement, it will be another 2 years in the relationship, and then lodgement of partner visa application, where basically you're going to be repeating the claims and confirming that you are still in relationship. Important point, a lot of people think that when they apply for permanent residency stage, they only need to show that they've been in relationship at the time of lodgement, and then it does not matter. So that's not correct. And you have to be in relationship with your partner until pretty much the visa is granted. So if at any stage the relationship just deteriorates and cease to exist with no domestic violence involved and no children in common involved, in this case, you will not be able to proceed and get permanent residency. So there are also two scenarios where you can get partner visa, temporary and permanent, at the same on the same application, pretty much in one stage. This may be the case where the applicant and sponsor are in a long-term relationship, so together for at least 3 years at the time of lodgement, and then those 3 years can be covered by sufficient evidence, of course, again, 4 pillars, or the applicant and sponsor are together for at least 2 years and have a child in common. So in this case, for example, if the applicant originally came to Australia on any other temporary visa and it's a relationship going on, so you can use that opportunity to kind of skip 2-stage process and then get temporary and permanent visa in one go. So when we're going to be talking about partner visa from offshore, from overseas. This visa type usually recommended if applicant and sponsor will continue to reside together while overseas and wait for their visa processing time. Because otherwise, if say sponsor will travel to see the applicant, quickly get married overseas, and then rushed back to Australia, you don't have sufficient evidence of your relationship, and the processing time will be around 2 years. So it will be very torture to live apart or travel to see each other and then pretty much wait for the visa processing time. So I would recommend to use offshore partner visa option, subclass 309, when the applicant and sponsor basically is happy to reside together overseas and wait for the visa processing. Usually that's the case where applicant and sponsor been living together already overseas, and all of a sudden they make a decision, okay, in a couple of years we would like to relocate together in Australia. Then that's going to be the best fit. The other option I would like to talk about in the space of partners visas is partner visa for New Zealand citizen. So when we were talking about 300 visa, partner visa 820 or partner visa 309, in the majority of cases, the partner from Australia must be either Australian citizen, Australian permanent resident without any restriction in terms of being sponsored as a partner before or sponsor any other partner before, or eligible New Zealand citizen. And that's a careful consideration, because New Zealand citizens who will be able to satisfy the requirements to be eligible New Zealand citizens usually been living here for quite some time, and usually been living here or been here before 2001. It can be checked by requesting the movement record if you have the case where the partner is New Zealand citizen but been here for quite some time. So you can request movement record to actually check the date when this person relocate to Australia, to see if you can apply for standard partner visa. If that's not the case, a lot of New Zealand citizens been living in Australia for quite some time, but they did not satisfy the criteria to be eligible New Zealand citizens. However, New Zealand citizens living in Australia, say for the past 5 years, may be eligible for Australian citizenship anytime now. And in this case, if that's your case, then your partner who is currently New Zealand citizen, if they're eligible to apply for Australian citizenship, they need to do that first, get the Australian citizenship, and then consider partner visa option. If, for example, that's the case where you met New Zealand citizen overseas or in New Zealand, and you are in a relationship and you would like to relocate and live together, there is specific visa for that purpose. Subclass 461, pretty much partner of New Zealand citizen, relationship with New Zealand citizen. In this case, you can proceed with either being in de facto relationship, living together for 12 months, or you can, again, utilize visitor visa to come to Australia, then get your 3 months living together, plus registration of your de facto relationship if you're in eligible states, or get married either with recognized marriage from overseas or from Australia. But for this scenario, there is no option of prospective marriage visa. So if you have New Zealand citizen who only recently came to Australia, or you relocating with New Zealand citizen from overseas to Australia, then there is no option of prospective marriage visa. It's only de facto registered in Australia, or marriage on its own. So again, even for New Zealand partner visa, you will have to satisfy 4 pillars of evidence of relationship at time of lodgement. And New Zealand partner visas is still lodged on paper, so by post, unfortunately, not online. And this visa is a temporary visa that allows the applicant to stay in Australia for up to 5 years. And this visa can be extended for another 5 years if this applicant is still in a relationship with New Zealand citizen, or if the relationship finished and the holder of 461 visa is no longer in any relationship. So even if the relationship broke down, you can still extend 461 visa. 461 visa is independent stream, so it does not have clear and direct pathway to permanent residency. So it's a temporary visa. In terms of processing time for all of these visas, again, if you would like to meet with your partner soon enough, it's definitely visit visa. You cannot meet quicker than that unless your partner is going overseas to meet you. Then talking about prospective marriage visa or partner visa, onshore or offshore, prospective marriage currently may sit on consideration around 12 months time. Sometimes it's quicker than that, but I would not be optimistic for each and every application. Then talking about partner visas variety with Australian citizens, with New Zealand citizens, we are talking about at least 12 months plus consideration. And if we're talking about transition from temporary to permanent visa, 820, 801 or 309, 100. So for permanent residency stage, we're also talking about 12 months plus consideration. Sometimes it may be issued quicker. However, the whole process may take around 3 years being together with this partner. So a lot of people have misconception that if we're getting married, then it's pretty much done deal and there is no need to show a lot of evidence. Marriage on its own will fit the brief. Unfortunately not. So marriage as such will not give you an opportunity to come to Australia and get permanent residency right away. So apart from marriage, you will have to show evidence of relationship. And in this case, it's important to understand that all this evidence must be produced and prepared at time of lodgement of your partner visa. Because the processing time is so long, my suggestion and recommendation for every case is to keep collecting evidence of ongoing in relationship and then show to department, upload it to your application to make it decision ready at any point of time. So when the officer will be assigned to the case, then it's going to be easier to process and finalize the application instead of requesting up-to-date evidence, because when you lodge the application and it's been 6 or more months, of course the situation may change completely and you may be no longer in relationship. There was a case a couple of times, consultations coming through our office where the applicants thought that they don't need to be in a relationship any longer after they lodge permanent stage of partner visa application. However, the department came to them and request evidence and they couldn't produce it. And basically they could not achieve permanent residency because the relationship no longer exists. So you need to be mindful that the whole process, you have to be in relationship and it has to be backed up by evidence. As of now, the applications for partners in Australia doesn't have any age limit. So at any point of life, you may be hit by relationship and love matters, and then you can consider partner visa if that's a good fit for you and if you would like to relocate to Australia. Then there is no financial requirements for the sponsor. So there is limitation to sponsor 2 people through the lifetime of the sponsor, if we're talking about classic standard partner visa, where the sponsorship must be at least 5 years apart. And if we're talking about third or any subsequent sponsorship, it needs to be backed up by compassionate and compelling circumstances. If we're talking about sponsor to receive partner visa in the past, we need to consider again 5-year period since the partner visa was originally lodged, because there is limitation on that. So no financial requirements for the sponsor. They don't have to be at work or have to show some sort of income or savings, none of that. No English requirement whatsoever for partner visa, any of these options, which is a good point. And of course, you have to be in genuine and legit relationship with each other. So do not explore those opportunities of fake arranged marriage in the point of I'm reaching out to people who can potentially do that for me, and then payment happen or something else happen. Do not do that. The reason for that is, of course, it's fraud and it's against the law. And second, if you do stuff like that, department finds out, you will be first to go home. And the sponsor may actually decide at any point that the relationship will be finished. And even if you pay so much money to the sponsor or promise something, then it can be canceled and you will not have any leverage to actually defend yourself. So you'll have to go home. Interestingly, I would like to also touch the subject of, I would say, partner visa, but being a partner of a temporary resident. So sometimes situations happen that people get to know each other, and for example, one person is in Australia on a temporary visa. So in this case, you also can be added as a partner to those applications or pending applications, depends what sort of scenario we're talking about. Again, you have to show evidence of relationship, and the quickest actually option to get permanent residency is not through classic partner visa stages, because it may still take around 3 years from temporary to permanent residency. So the quickest option to get permanent residency is to be a partner for a person who will be applying for permanent residency, as an example, through skilled visa or through employed sponsored visa. In this case, you can be added as a partner at application stage, and then obviously you process the application together, where you're going to be a secondary applicant in the application, and you're going to get the permanent residency, I would say, maybe in a year time. So that's going to be the quickest option, maybe even quicker if the occupation for your partner will be in priority list. So it's interesting observation how many options of partner visa we have. And of course, our recommendation is to at least go through consultation as an initial stage, and don't assume that this option or that may be a good fit. So it all depends on your circumstances, and also depends on your plans, because visas preparation and consideration will take time. So every single applicant and their family member, their partner, will need to understand what's going to be happening in the process, and if that specific pathway will be a good fit for you. So thank you very much for listening for my life. I'm appreciative that some people be presented and listen. I see no questions in the live box, which is all right. So if you would like to clarify any questions after this live, you can drop the comment here on YouTube, or you can reach us out via booking the consultation, or via free assessment forms, or via email, and we will clarify your questions. Thank you very much for watching.